Call the first case, please.
State of Tennessee versus Seth Powell.
Good morning. My name is Sharif Gindi. I'm here for the appellant Seth Powell. I'm from Knoxville.
Can you pull that mic down a little bit?
Yes.
It's a little bit hard to hear you.
Sorry. Yes. My name is Sharif Gindi. I'm here for Seth Powell, the appellant. If I could I reserve 4 minutes for rebuttal, please? May it please the court. This is an appeal from the judgment of the criminal court for Knox County. Judge Green, G. Scott Green, was presiding. There was a jury trial, and this is a Tennessee Rules of Appellate Procedure Rule 3 appeal. I brought up four main issues in this case, and I'm going to try to focus on the top three, or the first three, or however many I have time to actually get to. Probably most importantly, I wanted to talk about there were 3 different convictions for possession of a firearm with the intent to go armed during the commission of a dangerous felony for 3 different drugs that the appellant was found guilty of possessing with intent to sell. And I'm asking that this court merge the 3 of those and on double jeopardy grounds. I do understand a case that had come out of the Western Grand Division that says otherwise, and that is actually brought up in the state's brief, and I'll get to that in a moment. So I'm asking that the court look more at State versus Harbison, which was the Supreme Court case. I do understand in that case, the court did find that there could be separate convictions for the 3 gun offenses, but I think the main difference there, and to me what it seemed the Supreme Court's intent was, this involved actual victims.
So the case that you said that came out of the Western Division, is that the case that was authored by Judge Witt? Is that Jones?
That is Jones. Oh,
okay.
Yes. Okay. Yes. I didn't.
Judge Witt.
Sorry.
Yes.
I didn't.
I just wanted to make
that.
sure we were thinking of the same case.
Yes. Mm-hmm. Yes. And I did not. That didn't click that you'd offered it, sir, that you had authored it, sir. Well, I guess what I'm asking, and that makes this a little bit more uncomfortable, but I'm asking that as the Eastern, being part of the Eastern Grand Division, that the court rule otherwise.
We're a statewide court, so that's not going to work.
Well, I understand. I guess what I'm saying is that the Rule 11 does contemplate what's the word they're using? The need to secure uniformity of decisions. So to me, I think it contemplates that different courts could come up with different conclusions.
So you're asking us to disagree with Judge Witt, the case that he wrote in Jones. You're asking us just to disagree with that?
Well, that's a very difficult ask. I understand that. I guess I'm probably not going to get very far on that.
I just didn't know if you had any other argument, because it seems like Jones is on all fours with this issue.
It is absolutely. It's exactly the same. It is both. What my argument regarding Harbison had to do with the fact that it was employing rather than just possessing. That it was there were separate victims as opposed to the possession crime, which doesn't point towards specific victims. I guess just as far as the argument goes, I mean, my reasoning for thinking this is there's a real difference between when there are different crimes involving different victims, and there may just be one gun involved, or frankly even just one shot fired, let's say, if it puts different people in risk, as opposed to the guns being in possession. And one difference, I guess, in this case is that they were constructive possession. I mean, that might make a difference. It was constructive possession. Nothing was found on the appellant himself, just some money. I guess I'm going to go to the next issue now. The other issue, which I'm asking for plain error review on, because it wasn't brought up before. Frankly, it was my client, the appellant, that brought this up to me sort of later. It was like, oh, that's something maybe we should have brought up, maybe at sentencing or at trial. This one of the substances that was found that he was in constructive possession of was a pink powder. And that pink powder had both heroin and fentanyl in it. So what ended up happening is, because obviously it was sent to the lab and both showed up, that he was charged separately with those two. I'm asking the court to consider that being essentially alternate ways of prosecuting the same thing. It's like one would be focusing on, well, we'll focus on the heroin, one will focus on the fentanyl, and that would avoid a double jeopardy issue if only, if they're looked at as different theories of the same crime.
But they're two separate statutes, are they not?
They are. I mean, they're two separate, yes. One is a Schedule 2.
And to violate either of those statutes, there's no quantifiable amount. It's just possession of that substance. Is that not correct?
It is correct. It is correct. I guess what I'm just saying is that it was sort of, it's the same stuff and it's different theories of what is it treated as. I think probably my better argument that I sort of just threw in here that I'd like the court to consider is maybe a sufficiency argument, because there's no evidence that the appellant knew that there were two different things in this. There was a phone call that was intercepted, or a jail call where he talked about some H. So if that meant heroin, then it seems that maybe he thought that this was just heroin. But there was no evidence that he or anyone knew that this was laced with fentanyl. It could have easily been that way when he got it, but there's no evidence that he knew that. And so I think there's an argument for sufficiency there on the fentanyl, at least. And that's why I'm asking that those two should merge in one case, or maybe there's insufficient evidence to find him guilty of the fentanyl because of the knowledge element, not as far as whether or not it existed. There was another point that I brought up that I think brought in some very damaging testimony that was clearly hearsay. So at one point at trial, I had asked a detective, it was Detective Logan Sammons, if he had any personal knowledge that the appellant lived at the house that was searched. This was a constructive possession case, and so if they couldn't somehow say that he lived in that house or frequented it or was staying there, then it wouldn't make sense that those drugs or guns were his. And when Detective Logan was asked about that, the question was, does he have any personal knowledge? Detective Logan replied with clear hearsay. He had a confidential informant tell him where appellant was, and had a City of Knoxville Police Department report that appellant was involved at the same address. I don't think there's any real. I don't understand why he would have thought that as personal knowledge, or how that could be construed to be personal knowledge. I mean, the question was meant, well, like, do you know something like yourself, that you saw yourself? And I thought that was pretty clear what the question was. But when I objected to it, I actually approached the bench to object. The court said, you asked the question. To me, meaning, well, you opened the door. I don't think I opened the door to hearsay by asking, does he have personal knowledge? If I said, well, how do you know that he lived there? Or do you have any, tell me something that points to that? That would have been one thing, and arguably I would have opened the door, but I don't think I did when I asked for, did you have any personal knowledge of it? Well, I'm not sure how much time I have left, but I think that's probably about it.
You have used up 10 minutes so far.
Okay. I think I'll just save the rest for rebuttal if that's okay.
Okay, all right.
Good afternoon, and may it please the court. Caroline Weldon on behalf of the state. Very briefly, this case stems from the investigation of a stolen AR-15 rifle. As counsel mentioned, Detective Sammons, a Knox County Sheriff's detective, learned that the defendant had purchased a stolen weapon and received a search warrant for the house where he believed that the defendant lived. When he went to execute that search warrant, he discovered the missing AR-15 rifle along with a .45 caliber handgun, cocaine, heroin, and fentanyl.
Let me pose this question to you, as it may help you in your focus on the rest of your argument. It seems to me this case is sort of pushing against the limits of the envelope in several respects. You have the issue raised about the fentanyl and the heroin being mixed together to create two offenses. I realize they're different. One's a class Schedule 1 and one's a Schedule 2. I learned, or at least I heard from another case we had, that heroin and fentanyl are very closely related, and sometimes fentanyl is substituted for heroin. So the question does arise, is this one offense or two? And then you have all of these gun charges that are tied to the possessions of different types of drugs under multiple theories of gun offenses. In this case, a little bit overbearing?
No, Your Honor, it's not. Given the nature of the drug operation that the defendant was running out of that house, the defendant had assembled a wide variety of narcotics, specifically cocaine, heroin, and fentanyl, and it appears that he was guarding that operation by arming himself with both the AR-15 rifle that he purchased and the .45 caliber handgun. And if you watch the surveillance, or not the surveillance, but the body-worn camera video and the photographs of the interior of the house, all of these items are assembled together as sort of the opening of a store, if you will, where people would come and presumably purchase those items from his house. So the combination of the different narcotics and his use of weapons to either to protect the narcotics that he had in his house, it is not overbearing, given all of those separate offenses are different crimes. The possession of the heroin, the possession of the fentanyl, the possession of the cocaine, all of those have been criminalized under different sections by our General Assembly, and by using or having the two different weapons in that same space, all of the charges were appropriate, given the way that the narcotics and the firearms were together in the living room.
Okay.
Let me ask this question. How, I know the defendant was charged separately with possession of heroin and with fentanyl. How was it indicted? Because it seems like maybe it was indicted as specific amounts.
I believe that it was indicted for with the different amounts. That's correct, Your Honor, but it was charged separately for the heroin and charged separately for the fentanyl.
But if it was indicted of so many grams of heroin and so many grams of fentanyl, the testimony, as I understand it to be from the TBI analyst, was that she couldn't quantify how much of each was in the total pink substance that weighed 30 some odd grams.
Yes, that's correct. It seems as though she was unable to separate the heroin from the fentanyl to be able to determine what amounts of each substance were present in that one bag.
So what did the jury convict the defendant of? Was it as indicted of over a specific amount of each drug?
Yes, it was, Your Honor. It was indicted for
Then how does the proof support that?
the proof shows that the defendant possessed the heroin and the fentanyl, and while they were mixed, they did not become different substances while they were mixed together. They maintained their separate qualities and remained different scheduled substances. And with respect to the differences between the substances, although they are closely related, they are different and they are separate. One is an opiate and one is a synthetic opiate. And I believe that in drug operations like the one that the defendant had in his living room, commonly fentanyl is used to stretch the heroin product and to be able to sell more of it. So he did possess both the heroin and the fentanyl.
I can understand that he possessed both, but if he was charged with possessing a certain quantity of each drug and convicted of possessing a certain quantity of each drug, how did the proof support that when the proof was that we don't know how much of each controlled substance was in that mixture?
We may not know exactly what amount of each controlled substance was a part of that mixture, but we know that it was at least 30 some odd grams. And the jury was able to understand by looking at the picture of this pink substance that there was at least a certain number of grams of each substance inside that bag, and enough to satisfy the charge.
Where was the defendant physically? Where was he when the officers went there to serve this search warrant?
He was on the porch of the house, and the evidence at trial showed that he was on the porch of the house, and as he saw the caravan of law enforcement vehicles moving towards the house, that he attempted to flee on foot.
But he was seen on the porch?
Yes, Your Honor. He was seen on the porch, and he was quickly apprehended, and I believe the yard near the house. And when he was apprehended, a bundle, I guess, for lack of a better word, of $1,600 of cash fell from his person. And the cash was organized in such a way that's indicative of narcotic sales. The bills were individually folded as though he were accounting for each transaction and then folding the amount that he received for each of those sales. The defendant, it's very clear that the defendant lived at this address. Detective Sammons knew that the defendant lived there because of his prior dealings with the defendant and his live-in girlfriend, Miss Hatmaker, and there are numerous photographs of the defendant inside the house. There's a family photo album bearing his surname on the coffee table in the living room. And the defendant made...
Is this the same place where the drugs were laid out?
Yes, Your Honor. And the defendant made several inculpatory statements while he was in jail awaiting trial for this offense. He laments that he was caught with the H and hard, and that the officers had taken $1,600 from him. And he also expresses anger about having been set up by the person who sold him the stolen AR-15 rifle that then set this whole course of events in motion. If I could turn now to the claimed errors in Detective Sammons' cross-examination. Detective Sammons was asked on direct examination, how did you know that the defendant lived at this house? And Detective Sammons said that he knew the defendant lived there because of his prior dealings with him and with his girlfriend, Miss Hatmaker. He doesn't elaborate further, but that's his testimony on direct examination. On cross-examination, he's asked to provide further explanation and to...
That's not the question. The question was, do you have personal knowledge?
Yes, Your Honor, that's right. He was asked on cross-examination, do you have personal knowledge? And it seems as though Detective Salmons attempted to offer additional explanation and said that he had reviewed a Knox County Police Department report and conferred with the confidential informant, who was the woman who sold the defendant the stolen AR-15
Well,
rifle.
he didn't testify to that, though, right?
I'm sorry?
He didn't testify who the confidential informant was.
That's correct. He did not testify who the confidential informant was, and there's no further testimony about the contents of this police report or who this confidential informant was. He simply says he essentially corroborated his understanding of the defendant's address by reviewing this police report and by consulting with this confidential informant.
In fairness, is that responsive? I mean, really, just in fairness. I mean, I'm not speaking to whether it's
Sure.
reversible error, but I'm speaking in the context of whether that's responsive.
Sure. I think in the context of both his direct examination and then the cross-examination, it seemed as though he was just trying to answer the question, and in a way that perhaps was not directly at the heart of personal knowledge, but it seems like he was trying to satisfy defense counsel's question. And with respect to it opening the door, that doctrine is just not in play here. There's no further information given about the contents of this police report or about the nature of his conversation with the confidential informant. Everyone simply moves on. He says, this is how I know that the defendant lived at that address, and there are no further questions really about the defendant's address of that particular house.
I mean, I'm not going to beat a dead horse on this one, but does defense counsel ask to strike the testimony?
I can't recall if he specifically asked for that remedy, but he asked to approach the bench and says something to the effect of, I don't think I opened the door for that sort of response, and the trial court says, you asked the question, overruled. And that's the extent of the exchange, as I recall.
Was this in the motion for new trial?
I believe that it was.
And the trial court just hung its hat on its same response?
I believe so, yes, Your Honor. It seems to think that you ask the question and then you cannot claim error based on the nature of the question that you posed. And again, especially given the context of the earlier testimony, it seems as though Detective Salmons was just trying to address or trying to answer the question as best he could. Turning now to merger. Merger does not apply to the defendant's convictions for possession of firearms with the intent to go armed during the commission of a dangerous felony. Again, the defendant possessed 3 different controlled substances, cocaine, heroin, and fentanyl, for the purpose of selling them, and each act of possessing one of these controlled substances for the purposes of sale constitutes a dangerous felony within the meaning of this statute. And as the court addressed earlier, this is on all fours with State versus Jones, and that constructive possession of both weapons and controlled substances.
But then the state comes along under other theories of gun possession and ties each one to each separate drug offense, right?
Yes, Your Honor.
And well, go ahead.
So again, we would just, the defendant possessed the 3 different controlled substances and 2 different firearms, and nothing in the language of the statute suggests that the legislature intended to limit the unit of prosecution to the number of firearms that he possessed. The legislature has expressly authorized separate employing a firearm charge for each dangerous felony committed, and this is very similar to that. It's not employment of a firearm, but it's the possession of a firearm. If there are no further questions about this particular merger issue, I'd like to move to the final issue dealing with the mixture of the 2 controlled substances. And we did touch on this briefly, but just to revisit it for a moment. The defendant suggests that because the heroin and fentanyl were mixed together, that they became one singular substance and thus a singular offense. But again, these are two separate substances. The bag was tested and found to contain heroin and fentanyl. The substances are different schedules, and they are different. They are different in that one is an opiate and one is a synthetic opiate. He is unable to establish the plain error factors because he cannot show that there has been a breach of clear and unequivocal law as it relates to these substances. He committed two separate crimes by possessing two separate substances, and he was responsible for this drug operation and its contents. So for all of these reasons, ask that you affirm the judgments of the trial court.
Okay, thank you. Rebuttal?
Yes, well, the court had brought up a couple of things that I did want to address. I think the main thing is, so looking at the transcript from when I objected, so, the question, like I had said before, do you have any personal knowledge yourself saying that he lives in that house? And then the response was, I did have a confidential informant come to me and tell me where he was at, along with the City of Knoxville Police Department report that he was involved in at the same address. I said, okay, Your Honor, could we approach? At the bench, I said, Your Honor, I'm going to object to that. I don't think I opened the door just because I asked him, and then I guess whatever I said, I must have mumbled because it's inaudible. And the court said, you asked the question, overruled. So I guess, I didn't get to the...
To the extent that was prejudicial, if we conclude that it was error, how is it prejudicial?
Well, because that was... it was so important for their case to show that he lived in that house.
Constructive possession. They're traveling on a constructive possession case.
Right.
So what?
If they can't connect him to that house, then
But
how?
they still don't. They don't directly. They don't have evidence of direct possession, right?
Right.
So what they're traveling on is constructive possession, a theory of constructive possession, right?
Right.
So how is this testimony, if it is error, prejudicial?
Because it's constructive possession, they would have to show some connection with him to the house. If they couldn't prove to a jury that he somehow that was his house or that there was a connection between him and the house, then how could drugs that being there or guns being there, how could he constructively possess them, or why would a jury think those must have been his?
They've got the mail in the house, the pictures in the house. They've got all this other evidence. What I'm trying to get you to tell me is what about this officer, in my view, this not necessarily being responsive to your question by saying his knowledge was based on an arrest report and a confidential informant.
Yes.
How is that prejudicial?
I guess the answer is it's just one more thing. Who knows what a jury would do with what they had? Were there other things like, well, maybe, and then this is like, oh yes, of course, then he's definitely connected to that house. I guess that's just it. It's just sort of one more thing towards that. Your Honor, you had brought up the amounts. I did look in the lab report, and it talks about they tested 34.38 grams, and there must have been another 10.2 grams that they didn't test. But it does look like it's not really clear how much of that is heroin, how much is fentanyl. They're both sort of under the same thing, the same thing that was tested, 001-A.
But there was evidence of an amount in the record.
Yes, Your Honor, there was. It looks like probably that total amount was 44.58 grams, yes. Well, and I guess I didn't really get to it before, and I probably should have, because I decided I wasn't going to before that I was going to be able to spend more time on the other issues. But I do want to make sure that I'm not waiving any argument regarding sufficiency of the evidence. there are some bad facts for sure. But one thing I think that is, I don't know, interesting to look at is when you're talking about constructive possession of both the drugs and the firearms, what points to possession with intent to go armed, possession of those drugs with intent to go armed? To me, it's just sort of, it's taking it too many steps away. Both the possession of the drugs and the possession of the firearms are constructive. So, and it was interesting, I don't know that this showed up in the record, so I'm sorry if I'm just saying something, but there was a question asked by the jury, what does with the intent to go armed mean? And we found that there isn't really a definition. So I think the response was something like it has its normal meaning or something like that, something that probably was not all that helpful for the jury. But I certainly think that's something to consider. What is the, when you're talking about that kind of distance from both things, how can you constructively possess firearms with the intent to go armed during the constructive possession of the drugs? If the court has any questions, I'm happy to answer any questions.
Thank you, sir. Thank you both for your argument in this case.